Hello, and welcome to the latest episode of International Law Chats, a podcast from the American branch of the International Law Association, or ABILA for short. I'm Milena Sterio, a professor of international law at Cleveland State University College of Law, and also managing director at the Public International Law and Policy Group.
And I'm Alison Macdonald, a barrister at Essex Court Chambers in London.
And I'm Chiara Giorgetti, a professor of international law at Richmond Law School and a non-resident faculty at the Vienna Diplomatic Academy.
Today, we're excited to be chatting to Michael Scharf, former dean and now associate dean and professor at the Case Western Reserve University School of Law. We will discuss Michael's career in more depth in just a moment, but by way of introduction, Michael is an innovative international criminal law expert whose career spans decades of academic and professional experiences. Michael Scharf is Associate Dean for Global Legal Studies and also the Joseph C. Hostetler BakerHostetler Professor of Law at the Case Western University School of Law. He also served as the law school's co-dean for over 10 years. Michael is also Managing Director of the Public International Law and Policy Group, a Nobel Peace Prize-nominated NGO. Before becoming a law professor 30 years ago, Michael served in the Office of the Legal Advisor of the U.S. State Department, where he held a position of Attorney Advisor for Law Enforcement and Intelligence and Attorney Advisor for United Nations Affairs and Delegate to the United Nations Human Rights Commission. In 2004, Michael trained the judges for the trial of Saddam Hussein, and during a sabbatical in 2008, he served as Special Assistant to the prosecutor of the Cambodia Genocide Tribunal. In February of 2022, Michael presented an amicus argument before the appeals chamber of the International Criminal Court in The Hague on the question of who has the burden of proof on the insanity defense in a case involving a former child soldier. Michael is the author of 20 books, 5 of which have won National Book of the Year honors. Since 2011, Michael has been the producer and host of Talking Foreign Policy, a radio program broadcast on Cleveland's NPR station and other NPR affiliates across the country, which is also available as a podcast. In 2019, Michael was selected for life membership in the Council on Foreign Relations. In 2022, he was elected president of the American branch of the International Law Association, and in 2021, he was elected to the Executive Council of the American Society of International Law. Welcome, Michael.
Thank you. That's a handful to get through. Thanks.
Well, we wanted to make sure that we highlighted many of your amazing accomplishments before we get started. Now, as I mentioned in my introduction, you have been a particularly innovative scholar and practitioner in international law. Back in the 1990s, you worked at the State Department and had been assigned to help draft the statute and rules of the Yugoslavia Tribunal. At the time, this might have seemed like a Herculean task, as we had not witnessed the creation of any new international criminal tribunal since Nuremberg. In addition, the idea that the Security Council could establish a tribunal as a measure which restores international peace and security was entirely new at the time. Can you please tell us a little bit more about this experience, and in particular, how you went about approaching this task?
Sure, Milena. So I had my dream job at the State Department. And one of the exciting things that happened is one of my best friend's mothers-in-law, Madeleine Albright, was appointed to be my client when I was attorney advisor for UN Affairs, as she was appointed to be the permanent representative of the United States to the United Nations. And that made for a really good relationship. Her special assistant was also a good friend of mine, David Shepper, who many of you know. And so together with them and some of my colleagues at the State Department, like Jim O'Brien, who now runs the Albright Group, and at the Pentagon, like Stephen Leppard, we basically dusted off the old Nuremberg Tribunal statute, and we added to it the Covenant on Civil and Political Rights, Due Process Rights, and then we added to that the Uniform Code of Military Justice Procedures, and that became the U.S. proposal that was sent to the UN for the statute and then later for the rules of evidence and procedures of the tribunal. And much of what we sent ended up being adopted.
You make it sound too easy, Michael. I'm sure it was a lot more complicated than that. Now, after your experience at the State Department, you entered academia some 30 plus years ago. While serving as a junior academic, you simultaneously co-founded the Public International Law and Policy Group, a now leading NGO in international law and policy, dedicated to post-conflict constitution drafting, peace negotiations, and war crime prosecutions. Again, there had not been much precedent regarding junior academics launching NGOs. What was your goal in launching the NGO? And talk to us a little bit more about that experience, please.
So while I was at the State Department, I had been teaching in the nights at Georgetown, and I fell in love with teaching. So I knew that I wanted to make a career change after 4.5 years at State. My other very good friend that was at the State Department was making a career change by going to Cambridge to get his PhD. And I'm speaking of Paul Williams. And the two of us had this wonderful lunch together where we said, listen, we're going to be joining academia, but we don't want to be stuck in the ivory tower. We came to State because we loved being in the field. How can we continue to do what we love and be academics and publish books and teach classes at the same time? We also knew that there were a lot of sort of graybeards and older people that had a monopoly on the work before international tribunals. And we didn't want to wait 50 years before we could argue a case or involve ourselves in a peace negotiation at that level. So we came up with the idea of creating the Public International Law and Policy Group. We got the Carnegie Endowment to fund our first year of that. We brought together a bunch of really talented people to donate their time for us. And in the years since then, we've done 24 peace negotiations. We've worked with 5 international criminal tribunals, 3 piracy courts. We helped create the Uganda High Court for war crimes. And we're currently doing work with Ukraine prosecutors that are prosecuting Russian war crimes. So it's been quite a successful ride for the last 30 years. And a lot of NGOs come and go, and ours has just continued to expand and get a lot of traction in the field.
I wanted to talk about some sort of specific legal developments that you helped to fuel. But I mean, just as a follow-up to what you just said, do you have any sense of what helps an NGO in this field to have that kind of longevity? Because I think that's really interesting.
Well, at the time, we were like many NGOs, we had an office, and it was right across from the White House, and it was quite expensive. And we, before COVID hit, decided that it was time to go virtual, that you could run an international NGO without spending a lot of money for office space. So that was one of the great decisions we made. Another one is we were originally reliant on USAID grants, and we decided to diversify just before the Trump administration came in and cut USAID. So we made a couple of really wise and prescient decisions. But I think the real answer was that we have a lot of people that are very committed to the work of the NGO. Most of them are academics who don't charge us money to work with us. So we're able to pay for their travel and their per diem, but their work is voluntary. And that's really what makes our NGO special.
And I want to look at an example of how you've helped to sort of push forward legal doctrine, if you like, because we know that later in your career, the DOJ's Regime Crimes Liaison Office invited you to be a member of the team that trained the judges, and we've mentioned this, for the Saddam Hussein trial, obviously a hugely important trial. And during a sabbatical in 2008, you also served as special assistant to the chief prosecutor of the Cambodia Tribunal. We know this as the EEC or the EEC. I mean, your time at that tribunal, you argued in favor of developing the so-called Joint Enterprise 3, which I remember being commented on when it came out, as a mode of liability under customary law. Now, this was quite an innovative argument, and it was developed, I believe, to assist the prosecution team in being able to bring charges against former Khmer Rouge leaders. I mean, firstly, perhaps you could just briefly summarize what that legal doctrine was. But then more broadly, I guess, my question is that in both of these roles, in the Saddam Hussein trial, the Cambodia Tribunal, you had to embrace and help to develop quite innovative approaches to international criminal law to be able to assist the prosecutors there. So what was this like, and what lessons, if you like, did you learn from those experiences?
Yeah, let me start with the second part of your question and start with the Saddam Hussein trial. When we traveled to train the judges of the Saddam trial, they had never been in a system with due process rights like we have in the rest of the world. They had been working under the dictatorship of Saddam Hussein. So we were trying to get them to understand the importance of due process rights. Their trial was going to be televised. We knew the whole world was going to be watching. So I told them they have to be like a pit bull about due process rights. And this is a story that appears in my book, Enemy of the State. My interpreter said, Professor, what is a pit bull? I'm not sure how to translate that. And I said, oh, in the United States, we have this dog that bites the neck and won't let go. And that's how persistent the judges have to be about due process rights of the defense in order for this to succeed. He says, oh, no, Professor, I'm not going to say that. I go, no, it's a great metaphor. Say it. He goes, Professor, you don't understand. In my country, the dog is not a pet. The dog is a work animal. It's not an animal that we particularly like. When we want to insult somebody, we call them a dog. If you compare our judges to the pit bull and you explain that it is a dog, they will get up and walk out and you will never hear from them again. And so this is something that was a real challenge throughout the Saddam trial. The whole ethos of what their experience was compared to what we were trying to teach them was so different. And so that was a big challenge. It's a challenge whenever you work abroad, but in particular, that was a story that stuck in my mind. With respect to the EEC, the importance of being able to use joint criminal enterprise liability is been recognized by the Yugoslavia Tribunal in its first appellate case, by the Rwanda Tribunal, by the Special Tribunal for Lebanon, and the Special Court for Sierra Leone. And we wanted the Cambodia Tribunal to be able to use that approach. The problem is the actions that occurred in that case all occurred in the 1970s and 80s before any of those precedents. So they couldn't use those precedents. They had to go back and say, what was the state of law when these horrible events occurred in Cambodia? And the only law out there was the Nuremberg trial. So what I did is I spent weeks holed up in a little office in Cambodia that didn't have air conditioning. I was all sweaty. I was there to all hours, and I was combing through the old judgments from the Nuremberg Tribunal and the Control Council Law Number 10 follow-up cases to see what they had said about this doctrine of joint criminal enterprise liability. And we wrote a brief where we said that Nuremberg, and this is the first time this word was ever used in a legal brief, we said it constituted a Grotian moment. It was a paradigm-shifting event when that concept and others were first recognized in international criminal law, and that they should be applied by the Cambodia Tribunal. And the tribunal ends up applying joint criminal enterprise 1 and 2, but saying that joint criminal enterprise number 3, which is like the felony murder rule in the United States and the UK and Canada and Australia, it didn't exist yet at the time of the events. And so it exists today, but they couldn't apply it. And that's how things ended up.
How interesting, Michael. Thank you so much. I'd like to maybe change the focus to another region and another of the many, many issues that you worked on. Because at one point, you also kind of temporarily switched from assisting with war crimes prosecution to assist on a different aspect, the prosecution of maritime piracy aspects in Kenya, in Mauritius, and the Seychelles. You also engage as a piracy expert with the UN contact group on piracy off the coast of Somalia. Now, this is interesting, very interesting to me, because I was actually serving at UNDP. I was a program officer at UNDP Somalia. And so piracy was something that we were confronted with really every day. So I'm really interested in seeing, how did you approach this problem? Prosecution and piracy suspect is something that the world had not witnessed in a very long time. So what types of innovative legal approaches were necessary? How did you deal with with something that is old, but it's very new, but old at the same time. What are some of the legal issues that you were confronted there?
Yeah, that was a great adventure for myself and my colleagues at PILPG, because piracy had not been prosecuted in about 300 years. And all the precedents were, as you said, very old. But suddenly in the 2000s, there was a spate of piracy, especially off the coast of Somalia. And the world was suddenly using universal jurisdiction to prosecute pirates in courts in Mauritius and the Seychelles and in Kenya. So I'd heard about this, and being a war crimes expert, I said, well, there seems to be a lot in common between piracy, which there aren't a lot of experts at, and war crimes, which I and a number of people were becoming an expert at. And so I asked a colleague of mine who was teaching a course of the history of piracy, if he wanted to partner with me. And I had this whole idea. I said, first what we'll do is we'll take my war crimes lab and we'll have the students work on issues that are before the piracy courts. Then we'll go to Mauritius, the Seychelles, and Kenya. We'll present the findings and the materials to them, and we'll assist them in their prosecutions. Then we'll talk with the United Nations about what we have found and see if they can use our expertise. Then we'll have an international conference on this, and then finally we'll publish a book. And my colleague rolled his eyes at me and he said, it's a pipe dream. You have all these fantasies. That's never going to happen. And as Milena knows, because I ended up partnering with her instead of my colleague, every one of those things did happen. And so that's what can happen when you have a platform like PILPG, when you have some experience. Now, there were people that said, get out of piracy. You're a war crimes expert. What do you know about this? This is not your specialty. But it turns out that these two specialties are really overlapping. And so it worked out great. And Milena and I went to Mauritius and the Seychelles and Kenya, and we ended up becoming very good friends with the prosecutors and judges there. We helped them develop their cases. And one of the most extraordinary challenges with the problem of child pirates, because the Europeans would just capture and release child pirates, just like you do if you're fishing and your fish is too small. And because of that, the regular pirates were taking more and more child pirates with them. They were convincing their parents to invest in their pirate operation by sending their kids out to sea. And so the UN asked Milena and I to do a presentation about what is the best way to deal with this problem of child piracy. And, there were all kinds of great ideas. You could treat them like child soldiers who are being prosecuted in international tribunals. But we came up with is the easiest approach and the most effective, and that is the courts should just consider when an adult pirate goes out with a child on board, that's an aggravating circumstances, and that escalates the number of years in the prison term. And once a couple of courts did that in Mauritius and the Seychelles, word got out, and it did have a dampening effect on the use of the child pirates. And so we were excited to be able to do that presentation and be able to contribute in that way.
I wanted to, obviously I'm a barrister, and one of my sort of daily interest is courtroom advocacy. And so I wanted to ask, because I know that you were the first law professor to make an in-person amicus argument before the appeals chamber of the ICC in The Hague. This was in the Ongwen case, and listeners may be aware that Dominic Ongwen was a former child soldier in the Lord's Resistance Army in Uganda. He was convicted of multiple charges of crimes against humanity and war crimes. And he himself, it seems, had been abducted by the Lord's Resistance Army and had been a child soldier. And his defense team raised the argument that this experience as a child soldier should be really significant mitigation at the stage of sentencing him. So can you tell us about the amicus argument that you made in that case, and also more broadly, how you found the experience of appearing as an amicus in the ICC? And I mean, I can say I've done that myself, and I was very aware of, I'd be interested to hear your experience. I was very aware of the fact that the amicus was not, you weren't part of the sort of established framework of the court. You weren't the prosecution team with their own places to go, and obviously you weren't the defense team, you weren't the victim's office, you were, so there's various kind of separate entity. And so I'd be really interested to hear how you experienced that very interesting case.
Yeah. So this was during COVID, and they gave us the option of appearing virtually or going to The Hague and wearing masks and just taking them off for a few minutes while we presented, putting the mask back on. And of course, we said we want to appear public in the gallery. So we went there. The legal issue was who has the burden of proof, the prosecution or the defense. In the United States, our states are divided pretty evenly on that. Our federal statute puts the burden of proof on the defense. Internationally, it's about 2-to-1, with the prosecution having the burden of proof in the majority, but there are a lot of states that still put it on the defense. And the question was, what should the ICC do for the burden of proof? Because there was nothing in the statute that answered that question. And the court itself didn't, at the trial level, make it clear who had the burden of proof. So this was the second amicus the PILPG presented that I took the lead on, and the first that we got invited to actually argue before the appeals chamber. The funny thing, and you probably have experienced this, Alison, I timed out my speech. We only were given, like 10 minutes to present, and I had it just right. And of course, you've got your headset on, and the interpreters say every couple of minutes, please slow down, you're going too fast. And I was not going too fast, although Milena was standing next to me and she tells me maybe that. But every time they would say that, I'd have to cross out a paragraph of what I planned to say. And it was a little distracting, but we got through it. And in the end, the appeals chamber cited our amicus brief and our argument 6 times. So we made a difference. And in the end, the appeals chamber decided that it was going to put the burden of proof on the prosecution after the defense had the burden of production. But we also raised the issue of this new regulation that a couple of the members of the appeals chamber knew about, but the others didn't. That's Regulation 51. And what that regulation says is that in the middle of a trial, if an issue like this comes up, they can pause and have a mini little hearing on the issue of insanity and then go right back to the trial without being particularly disrupted. And I think that information ended up being the key because they realized that they could do what I was asking without disrupting the entire process. So it all worked out. And we hope when the sanctions are lifted on the ICC that the PILPG will be able to do more amicus briefs in the future.
Thank you, Michael. Really a very interesting experience. And actually, you mentioned the sanctions, and I would like to kind of bring us back to more of maybe of a general and also maybe more a contemporary issue. You served as the president of ABILA in a particularly challenging time for international law. And I was wondering whether you have what your reflections on the presidency are and what international associations like ABILA can do in this challenging time. I know, for example, that you're a great supporter of the United Nations, and we are facing challenges from many different kind of directions. And I wonder if you think there is a specific role that ABILA can play in this context, or more generally to support international law.
Yeah, well, the biggest challenge that we faced this year was, of course, the Trump administration. And within the first month, the Trump administration had pretty much announced they were defunding the UN. They've subsequently cut $1.5 billion in funding for the UN. They pulled the United States out of the Human Rights Council, the Paris Climate Accords. The U.S. didn't send anybody this week to the negotiations down in Brazil for their delegation. And the United States said that they were putting sanctions on the prosecutors and judges at the International Criminal Court, and they were putting pressure on a whole bunch of countries and NATO and doing things that were basically undermining the international rule of law. So the board of directors of the American branch of the International Law Association said, we need to do something. but we don't really have a process for the board to make statements. The process is for the president to make a statement. So I didn't want to do that alone. We had a board meeting and everybody gave me all these great ideas. I integrated all their ideas into a statement. And a lot of organizations have stood up and made statements. The ASIL did, the American Bar Association did, the International Bar Association did. But ours is really pretty unique because it's like the Declaration of Independence of the United States. It lists all the concerns we have with what the Trump administration had done. And we put it in the context of the U.S. obligations to the international rule of law, to its treaty obligations and so forth. So that was released. We were all a little bit nervous, but I think in the end, I was motivated by something that Robert F. Kennedy said back in 1966 when he visited South Africa. And to paraphrase the quote, it was, each time someone stands up for an ideal, they send forth a ripple of hope. And I think when organizations like the ABILA and the others stand up for the rule of international law, that it is a combined ripple that can create ultimately a tsunami that might result in change. And I think it's our duty to do that, even though I know that it risks the ire and the retribution of those in power. And that's just a tough thing. When you're president of an organization, you have to make those tough decisions and you've got to show a little courage. And thanks to my colleagues, we were able to do that.
Michael, I have one more last question for you, which is really a two-part question. So you served as dean at Case Western Reserve University School of Law for 10 years, more than 10 years. And while you were dean, perhaps differently from other deans, you continued your work in international law. Why was that important for you? And then as a general matter, over the course of your career, what do you think has been your most impactful project or publication?
Okay, that's a great question. So my models or role models for deans were Harold Coe at Yale and Claudio Grossman at America. They were both great international law professors. They had worked in government and international organizations. And while they were dean, they continued to be very active in the field. And I felt it was important for me to do that as well. I didn't want to take a 10 or 11 year break from the field and try to get back in. I had much I wanted to contribute. And as things were going wrong around the world, I wanted to get in there and try to have an effect on that. So during my deanship, I did manage, through late nights and weekends to write 4 books and a dozen articles. And I would say, in addition, I organized annual conferences, some really good expert meetings, like a recent one on whether the Geneva Conventions are in need of an update. But the most important thing I probably developed during that time was the concept of the Grotian moment. And as I mentioned to Alison, this came out of my work at the Cambodia Tribunal. And it really starts with the Nuremberg trial. But I, in these books, applied it to a bunch of different case studies. And I ultimately wrote, along with Milena and Paul Williams, a follow-up book about Syria and one about Ukraine that just came out. Oh, if you look behind me, those are actually the book covers of those 2 books. And they basically apply the Grotian moment concept, the concept that sometimes there is an event that is so fundamental that there's a paradigm change and that customary international law is accelerated and it is created sometimes with less state practice and a lot less time than is common. And so that was like one of my big developments during my deanship. And I'm really glad that I was able to find the time to continue on that, because this Grotian moment concept is starting to take off. The United Nations Special Rapporteur on the customary international law cited it. It's being cited all over the place because it's an easy word to say. And it captures a concept that was counterintuitive. And that is that customary international law, which usually we think of as crystallizing over decades or centuries, sometimes happen really quickly. And in the world we live in now, we need that.
Well, Michael, I think that's quite a tantalizing note to end on. We've got to time. I mean, I think probably we need a part 2 for this podcast at some point. But thank you so much, Michael, for joining us today, supporting this podcast more broadly. And thank you for all those really interesting insights and observations on these issues, including, as you say, finishing with the idea of the moment that we're in at the moment in international law. I've really enjoyed this conversation. If the listeners have too, we are here on the first Monday of every month for more international law chats. And finally, as ever, thank you to our amazing producer, Freya Doughty-Wagner, for making this happen.
Thank you all for inviting me. This was wonderful.